Hi, everybody. My name is Eric Buchanan. I'm the president and owner of Eric Buchanan Associates. We're a law firm that helps people all over the United States who have been denied long-term disability or individual disability insurance benefits. We help with ERISA benefits. We help with other benefits that are related, like life insurance, large health insurance claims, or long-term care claims. If you have any questions about any of those, please reach out on the World Wide Web at buchanandisability.com. Thank you for listening today. One of the questions people ask us a whole lot is, what is the standard of review in these ERISA cases, and what does that mean? Or they ask, what does de novo mean, or what does an arbitrary and capricious standard of review mean? So I want to talk about those definitions today, and then I want to talk a little bit more about how ERISA came to have such an unusual set of standards of review, why those things are so weird, and what's frustrating about them if you're somebody who has an ERISA claim. So first of all, ERISA is the Employer Retirement Income Security Act of 1974. It was a law passed in the 1970s that was designed to help people who have employee benefits, mostly originally about pension plans, but it was eventually designed to cover other employee benefits like health insurance, life insurance, long-term disability. And so over time, courts have developed a system of how it's going to hear cases, how courts are going to decide ERISA claims. So if there's a dispute between an individual person who's been denied benefits and an insurance company, the court will use this standard of review concept to decide how to actually look at these cases. And that's what we're going to get into today. So first of all, just generically speaking under the law, before you even get into the concept of what ERISA covers, the law in England for several hundred years and in the United States going back to our founding has had this concept of a de novo review and also a deferential standard of review. And this history goes back to trust law largely. And so what is trust law? Well, if somebody passes away and they leave their money in an estate, or they leave their house and their property in an estate, a trustee is somebody like the executor who is assigned the job of making sure that all the heirs get that money or get the property. And it's possible that the person writing a will might say in there that I'm going to leave all the household goods to my 3 children, and my oldest daughter will be the executor of this will, and she gets to decide at her discretion who gets what household furniture, who gets what household goods, who gets what plates and what silverware and what other family heirlooms. And the courts have for hundreds of years said that someone in that position, an executor of an estate, has a special duty to the people who are actually getting the goods from the estate. And that special duty is that the person is a fiduciary and has an obligation to be fair and not engage in self-dealing. But at the same time, the courts have said, if the mother trusted this person, the woman who passed away trusted her daughter to be the executor, we're going to give deference to the oldest daughter's decisions on how to hand out the household goods. And with that deference, the court will say, we're not going to listen to the other brothers and sisters complain unless they can show something was extremely unfair, that it was arbitrary and capricious. And that's a concept that's been around for a long time. There's also more generally trust law, and this is typically in English history where a wealthy person wants to ensure that they're leaving money to their oldest child, back in the old days to the oldest son, in order to maintain that property going forward. And there's little issues in English common law going back centuries about how long you can make that last. Can it last multiple generations? Can you leave property to only the oldest heir year after year after year? If you've ever watched Downton Abbey, that's part of what's going on in that movie, is that the Lord Grantham has been made basically the trustee of the money that belongs to the family and of the castle, the estate, and eventually he turns it over to his daughter eventually, supposedly, under the show. He got that before him, generation after generation. So there's concepts within English law that are carried over to American law that if somebody wants to leave a stack of money to somebody, maybe the person who actually is going to get the use of that money is not ready to control a large fortune or a big amount of money. So the older person who's going to pass away knows of leaving it behind, might put it in trust where somebody is the trustee who ensures that that money can only be spent certain ways. And so the owner who originally sets it up sets up this trust. It's called the settler of a trust, if you want to get technical, puts that money in a trust, and then the trustee gets to decide who gets what money when under the rules of the trust. Well, one of the things that original settlers of trust, the rich people who put the money in the trust, could do is they could give the trustee discretion, and the discretion would be you can give up to 20% of the money right away, but the rest of the money you have to give only when the surviving heir has shown a sufficient amount of maturity, or a certain amount by the time they turn 30, or once they get married, or once they have kids. And if it's a certain act that has to be done, then that money has to be given away because that's what the trust said. But if the trustee has discretion to give a portion away, then courts typically say that meant that trustee was trusted by the person leaving the money behind. And if they, being the trustee, have discretion, the courts won't overturn that if the heirs, if the people who are the beneficiaries of the trust, who are getting the money, if they want to complain and sue and go to court, they better have a darn good reasons. They have to show that the trustee is acting arbitrarily, capriciously, in a way that's blatantly unfair. Otherwise, the trustee won't be overturned. And that's a concept of trust law that's been around again for centuries. At the same time, the trustee is a fiduciary, and the trustee has an obligation to treat everybody fairly, everybody who's getting money from the trust fairly. And those fiduciary responsibilities say they have to maintain the assets in the trust at a level that's what a reasonably prudent person would do when they're looking out for someone else's money. They can't self-deal. They're not supposed to give themselves more than their fair share. They're not supposed to invest, for example, in their own private investments that helps them when it's not fair for the rest of the beneficiaries. All that kind of self-dealing is a problem under trust law. But the law basically says as long as they're being somewhat fair, not self-dealing too much, then if the trustee has discretion in the trust documents, then the beneficiaries, the people getting the money, can't go to court and sue to say, well, he or she's doing it wrong, they're being unfair, unless it's really unfair. If it's within the realm of reasonable discretion, and it might even be something the court disagrees with, but as long as it's reasonable, the trustee's decisions won't be overturned. That concept of trust law that applies to trusts and wills has been around once again for centuries. Well, when ERISA was first passed in the 1970s, one of the things that Congress did was they said that we're going to look at this trust law and we're going to adopt that as part of the whole pattern of how ERISA law is to be interpreted. So they wanted courts to interpret ERISA under trust law because these employers are maintaining large sums of money in these pension plans and other benefits for their employees. They also have to act as fiduciaries. But the court also said, the Congress could also said that courts could look at contract law and insurance law and combine this all together in a way that was fair under ERISA. So back to these original concepts. So when Congress wrote the law, the question was not answered in the original ERISA statute. If these cases go to court, will courts treat these employers and the insurance companies offering benefits like they are a trustee with discretion, or will they treat them as if they are someone who is basically arm's length transaction people? So are they caveat emptor, let the buyer beware, is one of the ways that people look at it. What does that mean in plain English? Will the court just treat it as a contract between two equals? So if an insurance company is denying a claim, does the insurance company get any special benefits like as a trustee, or is the court going to analyze what they did as if they were just equal to the person who's been denied the benefits? And so what the law has done for centuries is if there's not discretion granted in a trust, if there's not discretion granted in a will, is the court will apply something called a de novo standard of review. Well, what does that mean? That's one of those Latin sort of French words that came into English as part of our legal system after the Norman Conquest. So we're talking about for 1,000 years, we've had this concept out there. And what it basically says, what de novo basically means is we're going to look at it afresh or anew. And so how does this apply at law in the American system and also originally in the English and British system? Was that if the court is exercising de novo review, the court is going to look at each side equally and weigh the evidence without giving the benefit of the doubt to one side or the other. Now, there's some disputes depending on how de novo is applied, whether that also means that you can consider new evidence if it's de novo and start all over again. So like the court gets to actually hear new complaints about the trustee or hear new complaints about the decision maker. And so that's one of the disputed things, that maybe de novo means you get new evidence, but sometimes it means you don't get new evidence in, but we're just going to look at the evidence that exists and balance it fairly and decide without giving the benefit of the doubt to either side. The court says, what would I do? What do I think is the most reasonable outcome? And that's the whole concept of de novo standard review. So to sum it all up before we get how it applies to ERISA, before we get into that, let's just be really clear about this whole tradition of British common law says the trustees and executors of estates, people like that, are fiduciaries, and they have an obligation to be fair to the people who are getting the benefits of a trust or a will. They have an obligation to treat it with special care. But the other side of the coin is the person setting up the trust or setting up the will can give that trustee discretion. And with discretion, then they can make decisions that courts won't overturn if they're unreasonable. In plain English, they can make a decision that might seem to not be what everybody would think is the best decision, but as long as it's reasonable, courts will uphold it. Courts give trustees and other fiduciaries who have discretion the benefit of the doubt. Sometimes courts have even gone so far as to say, well, we're going to apply that discretion to say it has to be laughable or downright unreasonable because trustees are given a fairly high level of discretion. Well, once courts started applying this concept to ERISA cases where people have life insurance or health insurance or long-term disability at work, the courts had to decide, well, what standard review are we going to apply? How does this actually work if an insurance company is denying benefits and the insurance companies who handle these claims are sort of one of the fiduciaries under ERISA? How are we going to deal with this? And there's a little bit of a history here I want to go into that just tells us how it happened. Then I'll get to an important Supreme Court case. So what is that history? Well, when ERISA cases first started going through the court system in the late 1970s, some parts of the country, they're called circuits, where several states have one appeal court over them, several circuits looked at, well, in the past, when it comes to fights over employee benefits, we've had those cases handled through the National Labor Relations Act, and the National Labor Relations Board would make a finding that would be reviewed later on by courts about these employee benefits, and the courts would give deference to the National Labor Relationship Board, and courts would give deference to the findings of fact below, sounding a whole lot like the deference in trust work where the trustee gets the benefit of the doubt if they have discretion. And so what had happened in the 20th century was administrative agencies and other government agencies that had administrative bodies that would make findings of fact, courts had adopted this idea that they would get discretion the same way that trustees would get discretion, that they would get the benefit of the doubt. And if somebody didn't like the outcome of what this administrative agency did, then you could take them to court. But in federal court, the court would only look at the final findings of the administrative agency. Did they apply the law correctly? And their findings of facts are going to get deference because they acted like a court below. They're not technically really a court because it's an administrative agency, but the courts in the 20th century basically said, we're going to treat it like it was a lower court. We're going to treat it like it was a trustee. We're going to give deference to their outcome. And so some circuits said under ERISA, we're going to only apply this arbitrary capricious standard review. So even though it's a private insurance company, we're going to give the private insurance company the benefit of the doubt that they decided the case properly. And so courts would say, well, I don't necessarily agree with this outcome, but the insurance company has deference, they have discretion, and so we're going to give them the benefit of the doubt. Other parts of the United States, other circuits, applied a de novo test, and they said, look, this is not a case where there's a lower administrative agency making a decision. It's an insurance company, or it's a ERISA plan that's funded some other way and maintained some other way, but basically it's like an insurance company deciding whether the person's entitled to benefits or not. And ERISA is supposed to protect employee benefits. And so if the case goes to court, the court should look at each side fairly and decide whether this person's actually entitled to the benefits, whether they're really disabled, whether they're really entitled to the health insurance benefits. And there was a split in the circuits that lasted from the late 70s all through the 1980s. Well, in 1989, this all came together in the Supreme Court in a case called Firestone Tire versus Brutch. And in that case, Justice O'Connor wrote a very famous, long opinion. And in that case, she spent a lot of time explaining this whole history that I've been explaining today, that ERISA, when Congress wrote it, adopted the ideas of trust law and fiduciaries having discretion, and that fiduciaries had the obligations of fiduciaries, that those concepts were adopted, but Congress wasn't explicit about the standard of review and how to deal with the history of discretion. It was all just implied when Congress said courts should look to trust law. But it was designed to protect employees. And so what Justice O'Connor spent the majority of her opinion talking about is how important it would be for ERISA to be fair, and therefore the normal standard of review should be de novo, which is the good standard of review if you're the person seeking benefits, because it means your evidence is going to be counted equally to the insurance company's evidence. The reasons you think you should get the benefits are counted equally to the reasons the insurance company thinks that you should not be entitled to benefits. And so that would be the most fair way to look at it from our standpoint when we're helping people fight to get their benefits. Unfortunately, and I laugh because it's just so frustrating. We've been dealing with this now for a long, long time. Unfortunately, what Justice O'Connor said toward the end of the opinion is, after laying out all these reasons why ERISA was designed to protect people and to protect their employee benefits, and therefore the standard review should normally be de novo, then she went and looked at the restatement of trust, which is a legal manual that you learn about in law school, that judges look to. It tells the history of the law and history of what people said in the law over the centuries of British and American law. And what the restatement of trust says is, well, if it's a trust, then of course the parties can agree to have discretion given to the trustee, so that if a fiduciary is granted discretion in the documents, then they can have discretion. And Justice O'Connor spends a couple paragraphs at the very end saying, all this stuff about de novo I've said is great, unless the parties agree on a more limited standard of review. And of course, that's fine under trust law. But well, wait a minute, but you've said all this stuff is important for it to be de novo. So who are the parties to agree, and what do they have to say? Well, in ERISA cases, the party is not the working person, the employee. The parties are the insurance company and the employer agreeing to offer these benefits and setting up all the documents under which the benefits are provided. And so it's the employer and the insurance company agreeing that there's a more discretion given to the insurance company, that the deference should go to the insurance company. And so the insurance company can make their decision, and even if it looks unfair, it gets upheld as long as it's not arbitrary and capricious, as long as it's not downright unfair. And that's what Justice O'Connor basically said, is the parties can agree. And the parties being the insurance company and the employer, they can give themselves discretion. At the very end of the case, they also said, she also said, well, by the way, the rules of trust law says we should also look at any conflict of interest, but she didn't really explain that very much. And we'll talk about that in a later podcast or a later video. Well, what happens after that case is decided in 1989? After the case of Firestone Tire versus Brutch comes out, where Justice O'Connor says that the parties can agree to a more limited standard of review, which means the insurance companies, if they have discretion, would get the benefit of the doubt, and their decisions, they get to win. Their decisions are upheld in court as long as they're not downright unreasonable. They can be wrong and still win if they are reasonable under a deferential standard of review. So what do you think the insurance companies all did? They went out and wrote their policies to include language that gives deference to the insurance companies. And so the insurance companies have this language in almost all of their policies. They can win even if they're wrong, as long as they're reasonable about it. So when we help people, we have to fight that uphill battle. We have to help people overcome that by having such good evidence in their case, such good evidence in their file, that the insurance company looks unreasonable when they deny a claim. There's another thing that courts have said that over time that also is important to this, is that basically, if it's arbitrary and capricious, almost always the court's only going to look at the evidence that was submitted to the insurance company. Now, it's de novo. Some circuits have said you can put in new evidence. Some circuits have said, no, you can't even put in, even if it's de novo, you can't put in new evidence. But in all circuits, if it's arbitrary and capricious, you're stuck with the evidence you submitted to the insurance company. And so you have to make sure you have a good case by hiring a lawyer like us or hiring a lawyer who knows what they're doing to take your case and appeal it properly to the insurance company to make sure that documents are all there, that it's well documented just how disabled you are or otherwise entitled to the benefits. Well, there's also a little bit of good news. Some states have passed laws that says insurance companies, those laws will say insurance companies cannot grant themselves discretion. Some states have done that. Many states have not. There's a part of ERISA that says if a state law regulates insurance, it can apply even though ERISA is a federal law. So there's sometimes some courts have said, nope, you can't have discretion in this state, at least under these circumstances, because of the state law limited it. Problem is a lot of states have not done that. The other good news is there was a set of ERISA regulations that were updated at the very end of the Obama administration when they were leaving office in 2016, early 2017. They put out these new proposed regulations. And one of the things that they said was if the insurance company breaks the rules and doesn't apply the regulations properly in the way that they deny claims, the way they decide claims, then they can lose their discretion. Well, those regulations were supposed to go into effect in early 2018. When Donald Trump won the presidency, a lot of people were thinking, well, he's not going to like the Obama regulations and he's going to get rid of them. In fact, the Trump administration put out those new regulations. They were actually issued on time, and they said will go into effect. The only thing that changed was instead of being effective January 1st of 2018, they became effective April 1st of 2018. So any case where somebody has filed a claim for benefits after April 1st of 2018, if the insurance company does something wrong, they can lose their discretion. So attorneys like us who handle a lot of ERISA cases know how to look for those mistakes, look for those errors, and make that argument. But there's still a lot of cases that go to court where the court decides under this arbitrary and capricious standard review, which means the insurance company wins as long as they were reasonable, even if they were wrong. So what's the takeaway from all this? If you have an ERISA claim, if you have a claim where you got your insurance through work, you need to understand how the rules work, and you need to hire an attorney as early in the process as possible to make sure your record is fully developed, that the records before the insurance company are so good in your favor that the insurance company cannot reasonably deny you, that anything they do would have to look unreasonable. And you can't add that evidence usually later on in court. You have to get it in front of the insurance company. So if you are denied benefits, it's time to hire an attorney right away. You often only get one appeal, and that's the time to turn in that information to make your case so good that the insurance company would look unreasonable if they deny your claim. If you have any questions about this, you can look around our website for some more answers. Once again, at buchanandisability.com. If you have an actual claim and you want to learn more, feel free to reach out to buchanandisability.com and contact us there, or contact us by phone at 877-634-2506. I hope this helps people who have questions about this. And once again, feel free to reach out to our firm.